So let's get into it. First of all, thank you guys so much for all the sweet messages you sent me after yesterday's episode where I was...
Hi friends, welcome back to my channel. And you are not going to believe what Blake Lively's attorneys are doing in court right now. They are literally pretending as if they haven't subpoenaed 107 content creators and acting like there haven't been multiple letters filed by these creators seeking sanctions or protective orders against her. And according to Ellen Goff, who represents Wayfair, those subpoenas went out to all these creators, many of whom haven't even filed anything on the docket. And I'm one of them, because I didn't need to file on the docket, since right as I was about to file my motion to quash, Miss Lively decided to withdraw her subpoena against me. But not before my attorney had already spent more than 2 weeks working on it, drafting the motion to quash, preparing my declaration, and going back and forth with her attorneys, trying to get them to drop it. And it was only after these things started hitting the docket that she began withdrawing subpoenas, which is exactly what's happening with a lot of the impacted creators who are now writing letters to the judge. And honestly, I've debated writing a letter myself, maybe even without my attorney, using the same arguments they're making, because the stress, the financial cost, the emotional toll, and the time it took away from our jobs for those couple of weeks was huge, and simply withdrawing afterwards lets her avoid accountability in court. For example, Mackenzie folks, who had a tiny non-monetized channel with not even 1,000 followers at the time, literally only 2 subscribers, filed a document where she asked the court to review the motions to quash and the evidence in full, arguing that the subpoena lacked legal and factual merit and was part of a broader pattern of harassment, intimidation, and abuse of process, and that this withdrawal shouldn't shield the plaintiff from scrutiny or judicial oversight, but instead serve as documentation of misuse of subpoena power against a private citizen engaged in protected speech, urging the court to impose the most severe sanctions permissible under Rule 45. To send a clear message that such misuse of judicial authority by a high-profile litigant against a private individual will not be tolerated. These content creators, Mackenzie, Cassidy, Lauren, Ashley, are all pointing to Rule 45, which governs subpoenas and defines harassment as a form of undue burden that courts take seriously, telling the court that she's repeatedly filing overly broad requests to numerous people, showing a pattern of issuing excessive sweeping subpoenas, not to help her case, but to disrupt business, personal lives, and chill the speech of those targeted, claiming she's acting maliciously and in bad faith, with no proper motive, and looking at the overall pattern of her behavior as proof. Honestly, 107 subpoenas should be a giant red flag to any judge, and it could be why a protective order against Blake is being considered. Cassidy, for instance, referenced Rule 45 in her objections, noting that Blake used bulk subpoenas instead of targeting individuals. She said that 43 separate people weren't served separately, but in one bulk subpoena as if the court were a Costco, and that this wholesale warehouse-style approach was even more shocking because it was served across at least 3 different social media platforms, not all at once, but over weeks, each time with different requests, which bypassed both the letter and spirit of procedural rules that generally require subpoenas to be for one person. Cassidy argued the subpoenas were procedurally defective, issued in bad faith, abused the process, and were meant to harass, intimidate, and unmask anonymous speakers without court approval or showing relevance or necessity. And she called out Blake's attorneys for withdrawing only after motions to quash were filed because they knew the subpoenas had no merit. She also criticized the court for saying these motions to quash were moot now, warning that letting Blake get away with that would not only spare her judicial review, but also make it look like she won, leaving her questionable subpoena intact so she could keep using it against other creators, describing it as a buy one, get 59 free subpoena, and claiming Blake intended to keep plucking names to target at will without evidence or proper procedure. Cassidy accused Blake's counsel of misleading the court, bringing up irrelevant filings like Mr. Fritz's, and lying about why names were chosen for subpoenas, saying Blake falsely claimed they came from a list Wayfair provided, that she was unfairly targeted because Wayfair's counsel kept the list confidential, and that supporters believed her claims, leading to online targeting and damage to their reputations, which they couldn't defend because people trusted the court documents. Cassidy said Wayfair only later revealed the truth by removing confidentiality designations, proving Blake's claims false, and that without this, their reputations would still be in question. She called Blake's actions especially distasteful, accusing her of making further accusations in documents meant to release them from subpoenas, lying about meeting with them, and setting absurd conditions like requiring for attorneys in a Zoom call for unrepresented people, forbidding recordings, and not allowing anyone else present, which was outrageous. All of this, according to Cassidy and others, shows a pattern of dishonesty, abuse of legal process, and a weaponization of subpoenas to silence critics, not to gather legitimate evidence. And while she may try to walk it back by withdrawing subpoenas, that doesn't erase the harm done or the need for the court to hold her accountable. Which is why so many are pushing for sanctions, judicial notice of her conduct, and a strong message that high-profile litigants can't use their resources to crush ordinary people's rights to free speech. None of the receivers felt safe to speak with her under those conditions. The intimidation was keenly felt. Ms. Hudson's misrepresentation to the public and his honors continues when she states there is no further information required from the subpoenas as to these specific third parties at this time, making this statement after the statement that she had met and conferred with us leaves the implication that she has in fact received information from these imaginary meet and confers as she deceptively uses the words, no further information. It cannot be denied that in order for there to be further information, some information had to have been provided. Since these meet and confers did not take place, this simply could not have happened and did not happen. Now, I did have a meet and confer with them, or at least my attorneys did, and some of them did. But it sounds like what's happening here is that the content creators that appeared pro se without attorneys were uncomfortable meeting with Ezra and the team alone because they were making everything on their terms and their terms alone, and then not allowing them to have their own representation or an advocate for them while they met with these attorneys, which truly is so intimidating. If you are someone that has never dealt with legal matters at all, and you're someone that you know isn't capable of hiring attorneys like Ezra, who probably charges $2,000 an hour, right? And then you've got 4 of them in a room with you. Page 2 of the docket 496 does not get any better, as it continues to imply there's a link between us and Wayfair in this mythological smear campaign, when she states Miss Lively's subpoenas were one part of the discovery process, and at gathering information to link the Wayfair party's activities to sources through YouTube and exultant creator accounts, which is an extraordinary claim since there is absolutely no link between our channels and the Wayfair parties. Instead of these insinuations, it would have been much more helpful for her to have supplied the court with the slightest hint as to why the names on the bulk subpoenas were chosen, or even the tiniest drop of the legal reasoning behind it. The lie is repeated that Miss Lively's counsel has met and conferred with various individuals, whose account information is the subject of the subpoenas, including the third parties who have filed motions to quash. When Shawell knows that these meet and confers did not take place and asks the court to deny them as moot, something we object to for the reasons stated herein. In her footnote, she mentions movements asking the court to revoke the subpoena as a whole, not just for movement, but for all involved state case law, informing that the court movement does not have the power to request that on behalf of anyone else. However, the reasons movement has stated and continues to state that make the subpoena invalid are not specific to a certain group of receivers. If the subpoena fails based on procedure, rules, and standards, it fails completely as a legal document and becomes invalid for all. That's accurate. Actually, she's also seeking a protective order, barring her from doing any more subpoenas or doing anything with DOE-type subpoenas, or anything anonymous. Find that this original subpoena was issued in bad faith and constituted abuse of process, and sanction in the form of punitive damages discourage plaintiff's counsel from victimizing others in the future, as movement has been. This motion was filed pro se, and no attorney fees were incurred. It did, however, take many hours of research and writing over many days and nights, interfering time that could have been spent creating content, leading to a loss of income. The threats of unmasking, given my specific circumstances, brought a great deal of anxiety and stress over the real fear of being found and victimized again. reigniting PTSD from a long-term stalking situation, and required extensive period of treatment. So Cassidy then filed a motion for sanctions and a protective order, and seeking a protective order, barring a reissuance of this subpoena, upon movement only on any platform to bar any further subpoenas to anonymous or non-party individuals without court leave. Award punitive damages as a sanction for abuse of process. Enter a formal finding on the record that the subpoena was withdrawn in the face of Maritu's legal challenges to protect the record from manipulation and grant other relief to the court deems just and proper, and she actually put together a factually, legally based motion to for sanctions. And outlined why she believes that she's abusing the court system, and she's reminding the court that this all started with a sham subpoena, where they used the Van Sandsham lawsuit, and now they're trying to do the same thing with anonymous people. Here's the issue for many of us that are, that had it withdrawn, is that there are only a handful of people that have notified the court, and there were 107 of us that were subpoenaed, which means that there's 100 plus people maybe at this point that are still being harassed by, Blake Lively. And at this point, we don't know if Google or Meta or X or TikTok are even going to do anything. It really concerned me that Google didn't do anything, didn't contact Matt, didn't ask them why they were seeking this information. They just said, oh, well, we might give her this information, based on what you know. I will say that the meet and confers were not about at all them telling us why their subpoena was relevant. Instead, it was accusing us, at least me, you're a part of this, we know it. But then also, I agree it was done in bad faith because she was claiming I was part of something that I was not, and then couldn't state what statements I had made, where and what statements, in what videos. Couldn't point to a single post, video, Instagram story, anything that she believes was paid for by Wayfair. Couldn't even state a single defamatory statement that I made. As Ellen Goff said in court this week, just because she thinks it's defamation does not make it so. That's not about criticism. That's not defamation. Another detail here is that Ashley Brown and Eve also filed a similar motion to the court for sanctions and such, all with the same arguments. And Perez Hilton filed for a motion for protective orders, and the judge hasn't acknowledged any of these filings at all. So, I don't know how he's going to react. And it would appear that Blake Lively's team is not addressing them either, just ignoring them. So, is he going to just ignore them and say, well, they're not. You don't need to respond because he has a stipulated rule that people need to respond to the letter motions within so many days, I think it's like 2 or 3 business days, and if Blake's team is not going to respond to these, then what happens? Does the court just ignore them and say, well, these people are just asking for stuff that doesn't matter? Well, we'll have to see. But Blake is getting hammered, and her team is getting hammered, and the judge does have the opportunity to do something here. He absolutely could sanction her. There's been a lot of threats of sanctions of Blake against everyone else, but now you've got legitimate concerns from private individuals who were brought into something that we're not involved in. And we have people that are supporting Blake, claiming falsely that we're a part of a smear campaign, and that does stain our reputations. So, we'll have to see how this plays out. I just want to say to the content creators that are making and fighting this in court, bravo. Hats off to you. Please keep standing up for freedom of speech. I have been so overwhelmed in my own issues going on with like a lawsuit I'm dealing with Robert Schidd and a raid that happened last week that I haven't had the time to even think about Blake Lively's thing situation, and when she withdrew her subpoena from me, I was like, okay, it's over. And I haven't decided if I want to even address the judge or if I should. But for now, I'm just glad someone is standing up, and thank you guys for doing that for all of us. And what are your thoughts, everyone? And let me know in the comments below. Make sure to give this video a thumbs up. Please make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thank you so much for watching. Bye besting.